All right, good afternoon. Welcome to March's Employment Law Update, Law Lab. Delighted to see you all today. It's our usual 1 hour update session. I'm going to cover a few cases this morning, and then I'm delighted to say that we're joined by Ronnie Brown, who is a partner and heads up our tax team here at Burness Paul. And Ronnie is going to do some top tips on off-payroll IR35, which I'm sure many of you sighed a huge sigh of relief this time last year when we were told that it was all to be put on hold for a year, and you probably thought that's fine, I've got a year. And here we are, almost the 6th of April, and IR35 due to kick in for private sector employers from that date. So really delighted to have Ronnie join us today to cover that topic. You'll have noticed, those of you that join these sessions regularly, that we've moved on to Zoom for the first time. That was one of the conditions of Ronnie joining the session today, because it's got the soft focus function so that he could look a bit younger. He said that we had to use Zoom, so that's why we've moved on to that platform for today's purposes. I, of course, haven't touched the soft focus button at all on my camera. She lies. So without further ado, if we kick off, I'm going to cover 8 cases today. Again, those of you that have joined these sessions before will know that I tend to start every case with, I think this is a really interesting decision, but I do think all of these 8 decisions are really interesting cases and all have quite a practical significance for you all. So the ones that I'm going to cover, I'm going to do, you'll have seen in the press, of course, the coverage of the 2 recent Supreme Court decisions, big decisions from an employment law perspective. So very briefly, I'm going to look at the Uber decision and also the MenCap decision. I'm then going to look at a couple of disciplinary decisions that have come through recently. So one is about whether it is reasonable to dismiss an employee who has been carrying out covert monitoring of his colleagues. And the second is whether it's reasonable to dismiss an employee for refusing to wear a face mask in these COVID times. And we're definitely seeing a trend in cases coming through in connection with COVID, whether it be health and safety cases or on the back of furlough decisions. But those sorts of cases are definitely coming through the system now. So that's our disciplinary cases. I'm then going to look at 2 discrimination cases. One is, what does an employer have to demonstrate in order to rely on the reasonable steps defence? And the other is whether the fact that you took a decision for good reasons is enough for a defence in a discrimination claim. Then I'm going to look at a tribunal procedure case all about mitigation. And then last but by no means least, my absolute favourite topic in the world, TUPE. I've got a TUPE case at the end to look at. And then once I've covered those 8 cases, I'm going to hand over to Ronnie to cover the IR35 stuff. As always, if I can ask you just keep yourself on mute throughout the session, just because of the number of people that are on the session, that would be great. But if you've got any questions, please do type them in the chat box and we'll try and pick up as many of those as we possibly can as we go on. And similarly, if you've got cases on the IR35 stuff, once Ronnie starts his presentation, if you want to type those in, we'll try and pick those up for you too. All right, so without further ado, let's kick on with the 8 cases that I said I would cover. The first 2, as I say, the Supreme Court decisions in the Uber case and the MenCap case. So on the Uber decision, as I said, I'm not going to spend a lot of time on it. We did a seminar on it a few weeks ago now, and the recording of that's available on the website. So if anyone wants to get a bit more detail on it, then please do jump onto that and you'll be able to pick up some more of the detail. But I suppose just at a high level, what is the significance of the Uber case? Well, it obviously relates to this whole issue of the gig economy. And so why did the Uber drivers bring the case? They brought the case because Uber were treating them as self-employed individuals, which meant that they weren't entitled to either holiday pay or minimum wage under the working time regulations. So they brought a claim to say, hold on, we're not actually self-employed. We're at the very least workers, if not employees. And the Supreme Court upheld the decision of the Court of Appeal that the individuals are actually workers rather than self-employed, and so are entitled to holiday pay and are entitled to minimum wage under the working time regulations. And the key point that I just wanted to cover off, or I guess the key point that came out of that decision is this idea that courts will look behind what is written into a contract, or the contracts that are in place that are designed to cover the relationship between the individual and the organisation. So in the Uber case, there was a contract in place that said that the individuals were self-employed, that they weren't workers, that they weren't employees. And what the Supreme Court said is that's all very well, but in reality, if you look behind the contract and what actually happened in practice, it's very clear that these individuals were actually workers of Uber and weren't genuinely self-employed individuals. And the kind of factors they took into account included things like there was no relationship really between the Uber driver and the customer. Although Uber issued an invoice which was meant to look like an invoice between the driver and the customer, that was never ever issued to the customer at any point. It was clear there was no direct relationship there. They also looked at the fact that Uber would recommend to the driver what route the driver should follow after they'd picked up the customer. And what Uber argued it was, well, it was only a recommendation. There was no obligation on the driver to follow that route. However, if the driver didn't follow that route and went another route and there was a complaint as a result of that, they weren't entitled to a higher payment or a different payment because they'd followed a different route. And similarly, Uber had I suppose, a sort of how would you describe it? Well, not a performance review system and stuff, but they certainly kept feedback on drivers and they gave points depending on the feedback that the driver got. And if the driver had less than a certain number of points, they would then terminate the contract with the driver and they could no longer use the Uber app. So all of these sorts of factors pointed towards more than just a self-employed relationship, and certainly more than the argument that Uber tried to run, which was all we were doing was providing a tech platform for the drivers. We weren't engaging them as workers at all. So really a very significant decision in the context of the gig economy. You'll have seen last week Uber announced that they are going to treat all of their drivers in the UK as workers. It will be interesting to see whether that extends beyond UK boundaries. But also what we're seeing is a number of employers are revisiting the arrangements that they've got in place with individuals that they treat as self-employed. And the kind of, there's a very clear guidance, I think, from the Uber case that the direction of travel, pardon the pun, but the direction of travel is very much with a view to trying to protect individuals in an economy where more and more people are working within sort of gig type roles in that way. So not a surprising decision, but quite a significant one. So that's the first Supreme Court decision. The other one I wanted to cover was the MENCAP case, and this will be particularly relevant to any of you that work within the care sector, but it also applies to other roles as well, where you are asking an employee perhaps to be within a certain distance of the organisation when they're on call. Some of the issues that arise in the MENCAP case will be relevant in those circumstances too. So the MENCAP decision or the MENCAP case relates to where you have employees who are required to stay overnight on certain premises in order to provide care to care users, but only, to service users. And the question was, is the employee working the whole time that they're on the premises, so whilst they're sleeping, as well as if their sleep is interrupted and they're having to provide support to the service users, or are they only working when they're awake and providing the services? Now, that obviously would have a huge implication for employers. What's happened in the past within the charity sector is generally employees are paid an allowance for working overnight, but they're only actually, their working time is only counted as the time where they're awake and providing services to the service user. The Employment Tribunal and the Employment Appeal Tribunal both said that was wrong, and that the employee should be treated as working for the whole of the time that they were on site, even when they were sleeping. And that would have a massive impact on the sector in terms of the cost and the payments that would be due to staff. So the decision for the Court of Appeal and the Supreme Court ultimately was, is that whole time working time, or is it just a time that the employee is awake and providing the services? And both the Court of Appeal and then the Supreme Court upheld the Court of Appeal's decision that the whole time was not working time. It was only when the employee was awake and providing services to the service user. It was only that time that could be classed as working time or should be classed as working time. And it was okay simply to pay an allowance for the rest of the time whilst the employee was asleep. I think it's quite a surprising decision. I think it's quite a surprising decision, particularly in light of about 2 weeks before the Supreme Court decision, there was a decision by the European Court of Justice on a very similar point. It was to do with a firefighter, and when he was on call, how close he had to be to a certain location at any time. And similarly, an IT worker who worked in the Netherlands, I think, and he was arguing that the time that he was on call, because he had to be within a certain vicinity of his workplace, meant that that should be working time as well. And what the European Court said in that case, and both those cases conjoined, was it is working time if it significantly affects the individual's ability to devote time to their own interests. And in my view, if you've got somebody who's staying overnight within premises, it means that that's having a significant impact on their ability to devote time to their own interests, and therefore, potentially is working time. So, of course, our Supreme Court doesn't need to follow the European Court of Justice decisions anymore, but I think those two decisions are quite different. So that's your two Supreme Court cases. Somebody's just asking, is it the same if you're providing support from home, for example, via a helpline? Yes, I would say if you're working from home, but you only have to take calls at a certain time, if you follow the Supreme Court decision, potentially it's only the time that you're taking those calls that you're on working time. And I think probably that's even more so if you're at home picking up those calls. You can see that there's more of an argument if the individual has to come away from the home and work somewhere else, that potentially that would be working time. But the Supreme Court decision in that case is no, it's not. So interesting couple of decisions. Moving on to disciplinary cases, again, I think both of these are quite interesting cases. This question of whether it's reasonable to dismiss an employee who carries out covert recording of their colleagues. And one of the reasons why I'm referring to this case, I don't know if you will have seen it yourself in practice, but we're certainly seeing more and more examples of employees covertly recording meetings with their employer, or even just covertly recording conversations with their colleagues. So let me tell you the facts of this case. The case is called North Bay Pelagic Limited against Anderson. So Mr. Anderson was a director with the company. It was fair to say the relationship between him and the company had broken down. There was a lack of trust between him and his employer, and it had become quite fractured. He suspected that somebody was accessing his computer and accessing confidential information on his computer. He had his own office, so he set up a camera in his office to try and capture whether anyone had been accessing his computer or not. His employer found out that he'd been carrying out that covert recording. He obviously hadn't told any of his colleagues that he was going to set up the camera, and they took him through a disciplinary process, and he was dismissed for gross misconduct, the specific act being the fact that he was covertly recording his colleagues. And the decision for the Employment Appeal Tribunal was it reasonable to dismiss in those circumstances? And again, I think in quite a surprising decision, the Employment Appeal Tribunal said it was not reasonable to dismiss Mr. Anderson. And what they said is employers have to balance the right to privacy against, in this case, his wish to protect his confidential information. And the factors that they took into account were the fact that there had been a breakdown in the relationship and there was a lack of trust between Mr. Anderson and his employer. Also the fact that he set the camera up in an office which was for his own use only. So it wasn't set up in a public place, it wasn't set up in a part of the premises where lots of employees would be recorded. It was set up in his office only, which was for his use only. But the other factor that they took into account was that there was actually no evidence that anyone was caught on the camera at any time, which I think is quite a surprising factor to take into account. Just because no one was caught or just because no one was recorded, does that mean it's okay to set up the covert recording? So it's quite an interesting decision. I think probably one of the factors at the heart of it was this relationship breakdown between Mr. Anderson and his employer, and that's perhaps what's kind of tipped the view towards it being reasonable for him to set up the covert recording. But I guess the point for you to take away from it is thinking about within your own policies and procedures, have you made it clear that employees should not undertake recording without the employer's consent? And I know I've had discussions on this with a few clients on a few occasions where some take the view, well, we're very clear with employees at the beginning, for example, of a disciplinary hearing or a grievance hearing, that they're not allowed to record, and if they do, that could result in disciplinary action being taken. We send that to them up front in the letter when we invite them to the hearing. Whereas other employers take the view, well, they might not have thought of it until such times as we said to them they're not allowed to do it, and it might then encourage covert recording. So I guess it is a bit of a balancing act, but just thinking about, are you clear with your employees on what the position is in relation to covert recording? Because as I say, it is something that we see happening more and more often. So that's that case on covert monitoring. The other case I said that we would cover in disciplinary is a recent case to do with a refusal to wear a face mask. So this is the case of Kubelis against Kent Foods Limited. Mr. Kubelis was a delivery driver for Kent Foods Limited, and his main customer was Tate and Lyle. So his role was to drive a delivery van in and out of the premises of Tate and Lyle. And Tate and Lyle had a policy introduced as a result of COVID where you were required to wear a face mask at all times. Whenever you were in the premises or Tate and Lyle's premises, you had to wear a face mask. The employee, he drove a very large truck where basically when he opened the door of his truck, he was sitting very high up if he was speaking to anybody. And he refused to wear a face mask whilst he was in his truck, whilst he was in the cabin of his truck. And Tate and Lyle had requested on numerous occasions that he wore his face mask, because what they said was, if you're speaking down to somebody, there's a risk that droplets will drop onto that individual and they could catch COVID. So they asked him on numerous occasions to wear his face mask, which he refused to do. They then said to his employer that he was banned from their site. And the employer tried to convince them to change their mind. They weren't prepared to do that. The employer then looked to see whether there was any alternative roles they could offer him. They couldn't find anything within their organisation. And so they dismissed him on the grounds of gross misconduct, which was failure to follow reasonable instructions and wear the face mask. And so the question for the Employment Tribunal was that a reasonable decision to dismiss or not? The tribunal in that case said, yes, it was reasonable to dismiss. And the reasons that they gave for that were, firstly, the fact that the employer had a handbook in place which had very clear rules in the handbook. So the handbook stated that employees had to be courteous towards customers and clients at all times. It also stated that all employees had an obligation to take reasonable steps to protect their health and safety and the health and safety of colleagues and also customers. And thirdly, there was a clear instruction within the driver's handbook that all drivers should follow customers' instructions on PPE. And so the tribunal took into account the fact that there were those very clear rules in place for the claimant in this scenario, and therefore it was reasonable for the employer to dismiss. They also took into account the fact that the employer did try and ask Tate and Lyle to reconsider their decision. They took into account the fact that the employer did try to redeploy the employee before they took the decision to dismiss. And taking into account all of those factors, their view was it was reasonable to dismiss in the circumstances. Like so many of these cases, of course, lawyers will always say to you, it depends on the facts and circumstances. What the tribunal did go on to say is it wouldn't always be reasonable to dismiss in those circumstances, and it very much would depend on the nature of the role that the employee is performing. So it's just something to think about within your own organisations, particularly when we're starting to look at a return to work, hopefully, in the summer. I expect you'll all be starting to think about, well, what rules and procedures will we have in place when we do have a return to work? And if you're thinking about implementing obligations to wear face masks, for example, to continue to social distance, etc., really just thinking about, well, what is the basis for those rules? Why are we putting them in place? Are we communicating them clearly to our staff so that they know the reason for them, so that if people do breach the rules, if you choose to, you've got reasonable grounds to take action. Okay. So that's my two disciplinary cases. Moving on to discrimination. Two cases here. The first one to do with the reasonable steps defence. I think this is a really timely decision from the Employment Appeal Tribunal. So reversing back a little bit first. Well, firstly, I'll tell you the name of the case. It's Allay, A-L-L-A-Y, UK Limited against Gehlen, G-E-H-L-E-N. As I say, let's reverse back a bit and start with what the law says. In a discrimination case, in a harassment case, if an employer faces a harassment claim by an employee, they tend to take two approaches. One is to say the incident never happened. That would be one way of defending the claim. Or if the employer accepts that the incident did happen, the employer can say to the employment tribunal, okay, it did happen, but you know what, we took all reasonable steps to prevent harassment from taking place in the workplace. And that's a defence to a harassment claim. If a tribunal is satisfied that the employer has taken all reasonable steps to prevent harassment in the workplace, then it's likely to be a successful defence to a harassment claim. So let me tell you about the facts in this case. An employee made a racist remark about one of their colleagues. That remark was overheard by another colleague and also by two managers. The employee who was subject to the comment brought a claim for harassment, and the employer sought to defend the claim on the basis that they had taken all reasonable steps to prevent harassment from taking place. So they acknowledged that the comment was made, but they said, we took all reasonable steps to prevent harassment taking place in the workplace. And in particular, look what we did 2 years ago. We took all our staff through a training programme on equality and diversity in the workplace. And so that demonstrates that we took reasonable steps, because your kind of common reasonable steps are making sure that you've got an equality and diversity policy in place, making sure staff are aware of that policy, and also making sure that you've taken staff through training on equality and diversity issues in the workplace. However, what the Employment Appeal Tribunal held in this case was, notwithstanding the fact that the employer delivered training on equality and diversity 2 years ago, that wasn't sufficient to enable them to rely on the defence of taking all reasonable steps to prevent harassment from taking place. And the reasons they gave for that was, firstly, the employee who made the comment was quite clear that in his view, it was just banter. Now, that employee had been on the training course, so that started to ring alarm bells for the Employment Appeal Tribunal. Secondly, the fact that a colleague and two managers were aware of the comment being made but did nothing. Again, the Employment Tribunal said, well, they were all on the training and they didn't do anything. That should have rang alarm bells for the employer, and the employer should have considered rolling out the training again immediately on the back of that. And I think that's quite important for us as employers in terms of, I guess, lessons that we're delivering to our managers. If managers witness behaviour that is potentially in breach of or is potentially harassment, if they stand aside and do nothing about it, they're potentially jeopardising the employer's ability to run the reasonable steps to defend. So it is important that managers take a proactive role in that situation. And so basically what the Employment Appeal Tribunal was saying is, if you want to be able to rely on the reasonable steps defence, yes, it's good if you've done training in the past, but that's not enough. You have to show that the training was substantial. You have to show that the training was redelivered on a regular basis. And ideally, you should also have a process to assess the effectiveness of the training, both immediately after it's delivered, but also at regular intervals thereafter. So, you may want to deliver case studies where they have to answer questions on the back of the training, but then perhaps in periods after that, whether it be kind of 3 months after, 6 months after, 9 months after, doing some sort of reassessment to demonstrate that that training is still effective. So really quite a high threshold, I think, is what's clear from that case. In terms of the employer's ability to rely on that defence, the Employment Appeal Tribunal have put in place quite a high threshold where what they're saying is you really need to be conscious of the quality of the training and also the regularity with which the training is delivered. So from a practical point of view, I think just thinking about within your own organisation, how often do we run the training? Do we need to refresh the training? How do we assess the effectiveness of the training if we want to be able to rely on that defence of taking all reasonable steps? And also just generally ensuring that the issues of discrimination within your workplace don't occur because you put your staff through appropriate training. So as I say, and as I always say, yes, interesting decision, but I think one that's good to have on your radar. The second discrimination claim that I said I would talk about is, or the question for the Employment Appeal Tribunal was, can an employer rely on the fact that they had a good reason for taking the action they did in order to defend a discrimination claim? So the This is the case of Chief Constable of Devon and Cornwall Police against Town. Mrs. Town was a frontline police officer. She fell pregnant and her employer carried out a risk assessment. And the outcome of that risk assessment was that she could remain with her team, but only if she was doing restricted frontline duties, which she was happy with, her employer was happy with, that was fine. However, the police force had a policy in place where if any employee was placed on restricted duties, they had to be moved to what was called the Crime Management Hub, which was effectively back office duties. And the idea behind that, particularly for employees that were pregnant, was, well, from a health and safety point of view, we don't want individuals working on frontline duties, even if they're restricted. We want them to do back office duties for their own protection. And in this case, Mrs. Town brought a claim for direct discrimination on the grounds of maternity, because what she said was, I have suffered a detriment as a result of my employer's actions, and that detriment, it's unfavourable treatment, and it's directly connected to my maternity and to my pregnancy. So she brought a claim for direct discrimination. And what she said is, you've moved me away from my team who were very supportive. I was doing work that I enjoyed, and that had an impact on my mental health. And what the employer sought to argue was, but we were doing it for good reasons. Surely it can't be unfavourable treatment if the reason why we were doing it was to protect your own health and safety. It was for good reasons. That can't be discrimination. And the Employment Appeal Tribunal said in that, or their decision in that case was, you can't argue that because you did something for a good reason, that means it's not discriminatory. What you've got to think about is the impact on the individual. And in this case, you had an individual who was saying to you, I want to stay in the team that I'm in, I'm happy to do restricted duties. And that was supported by the risk assessment that you carried out, which said that she could stay in her team as long as she did restricted frontline duties. So there was no reason for you to move her into a back office role, and therefore it was pregnancy discrimination. Okay. And I think for that case, for me, I suppose where it kind of resonates is we do often have conversations with employers where they're saying, well, you know, this individual is pregnant, so for that reason, we're thinking about changing their role to X, Y, or Z, and doing it for good reasons. I think it's always important in scenarios like that you're obviously having that communication with the individual themselves to see what their thoughts are on the potential changes that you're looking to make to the role before you go ahead and force through those changes, even if you think, as I say, that you're doing it really for good reason. So that's your two discrimination cases. 2 cases to go, the one on tribunal procedure and then the highlight on TUPE as the last one. So the one on tribunal procedure is all to do with mitigation of losses. So many of you will be familiar, I'm sure, particularly if you've been through a tribunal process with employees, that once the tribunal reach their finding, let's take the example of an unfair dismissal claim. If the tribunal decide that an employee has been unfairly dismissed, the next question that they have to turn their minds to is, well, what compensation should we award in the circumstances? And a tribunal award is made up of a number of parts. One is a basic award, which the employee is automatically entitled to if they succeed with their unfair dismissal claim, and it's calculated in the same way that a statutory redundancy award is calculated. The second is an award for loss of legal rights, effectively. So it's a kind of minimal award of about £350. And then the third part is compensation. So if I'm dismissed on Friday, if I get a new job on Monday on the same salary, I haven't actually suffered any losses, so I wouldn't get any compensation. Whereas if I'm dismissed on Friday and I'm out of work for 6 months, then potentially the tribunal can award me that 6 months salary. That's the loss I've suffered as a result of the termination of my employment. However, what the tribunal can take into account is the extent to which I've sought to mitigate my losses. So whilst I've been out of work for 6 months, what have I done to find myself an alternative role? Have I sat on my hands and just thought, oh, brilliant, I can't wait to my tribunal when I'm going to win and I'm going to get this windfall of money? Or have I proactively gone out and tried to find alternative employment to reduce my losses? And the case where this whole issue of mitigation was discussed recently is a Scottish case. It's Hakim, Hakim, against the Scottish Trade Unions Congress, where The facts of the case very simply were that the employee won the unfair dismissal claim. When the tribunal came to award losses, they took a very broad brush approach and looked at what the claimant's losses were, and then said, well, for various reasons, we're going to reduce that by 30% because we don't think he properly took steps to mitigate his loss. And the Employment Appeal Tribunal made it very clear that tribunals should not be taking that sort of broad brush approach of just applying a 30% reduction or a 20% reduction, whatever. They had to go through a kind of step-by-step process to assess the extent to which an employee had mitigated his losses. But the critical point, and the point that's important for employers, is that the Employment Appeal Tribunal made it clear again that the burden of proof is on the employer to show that the employee hasn't properly mitigated their losses. Often employers mistakenly think the burden of proof is on the employee to show that they've taken steps to mitigate their loss. So if you turn up in tribunal and the employer doesn't lead any evidence to show that the employee hasn't properly mitigated their loss, the tribunal can just go on the basis that they have done. The employee doesn't have to show that they have. It's for the employer to show that they haven't. And so I guess one of the reasons why I thought it would be helpful just to highlight this case to you is if you're in a situation where you've got an employee who potentially is going to bring a claim for unfair dismissal, you can take quite practical steps from the outset where you start to gather evidence of jobs that the employee could have applied for and didn't apply for, so that when you get to the tribunal stage, you're in a position, either yourself or through your solicitor, to be saying to the employee, well, this job was advertised on whatever date, did you apply for it, yes or no? And it's quite powerful evidence that if the employee's saying, well, no, I didn't, no, I didn't, no, I didn't, no, I didn't, it helps to show that they haven't properly mitigated their losses. And you probably more than anyone else will know about the type of job that individual did when they were with your organisation, what the job market is like for that job around about the area that they work in. And so gathering that kind of information is very helpful. It may be as well, depending on the nature of the role, that an employer wants to lead an expert or have an expert there to give evidence on what the job market was like in order to show that the employee hasn't properly mitigated their losses. The other thing you might want to think about is leading evidence about, well, to what extent did you sign up with employment agencies? We know that that agency had X number of vacancies within that period of time, etc. So it's just a very practical step to be thinking about where you do think you're at risk of an unfair dismissal claim, taking those steps to start to pull together information on jobs that the employee could be applying for. The argument, of course, that we're seeing getting run more and more on the back of the pandemic is because of the job market, it's more difficult for employees currently to mitigate their losses. Although there is a counter argument to that depending on the nature of the role they do, because if it's a role where before it was very much based on location and you had to come into a specific office, of course, with people working more flexibly now, there's an argument that even if there wasn't a role within your locality, because of the nature of the role you do and the way in which the ways we work have changed on the back of the pandemic, actually that broadens the employment market for you because you could be applying for jobs in locations that you wouldn't have applied for previously. So mitigation and tribunal procedure, something to bear in mind. And then finally, I've promised you this from the very start. Again, those of you that know me know that I absolutely love TUPE, so I always like to throw in a TUPE case where I can. This case is absolutely crazy in my view, so let me share it with you. It's a case in relation to fragmentation, and the case I'm going to tell you about is a case of McTeer and others against Bennett and others. And very briefly, the facts in this case are Scottish local authority who contracted with Amy to carry out kitchen updates and kitchen maintenance within their housing stock. Amy then lost that contract and it was awarded to two new contractors, McTeer and Mighty. Now, what happened in practice is what commonly happens where prior to the TUPE transfer taking place, Amy looked at the staff that they had and tried to kind of do a bit of a rough and ready calculation of where they spent most of their time. So the contract was being split geographically between McTeer and Mighty. And so they kind of looked at, well, which staff worked mostly on the part of the contract that's going to McTeer and which staff worked mostly on the part of the contract that's going to Mighty, and that's how we'll split them up. And there was no exact science to it. But that is what commonly happens. And what you tend to find then is the parties to these sorts of arrangements try and work together to reach a pragmatic solution to work out who's going to go where. And ideally, from Amy's perspective, what they would want is all of the staff to be transferred either to one of the providers or the other. And so that's the approach that they took. Fine, all well and good. However, whilst that case was kind of rumbling on, we had a European Court of Justice decision in the case of ISS Facility Services against Goveats, which is Govearts, if I can read my own writing. And what that decision said was, in a situation where you've got employees who aren't clearly assigned to one contractor or the other, but actually could be split between multiple contractors, it's possible in a scenario like that the employee transfers to multiple employers. So prior to this European Court decision, the approach that was always taken really within the UK decisions was, if an employee's role is split between so many new providers that you can't actually assign it to any, what that means in practice is they have to stay with their existing employer and are either redeployed or made redundant. But what this European Court decision was saying was, say you've got an employee who's split 30, 30, 30 and 10, then they could transfer to each of those new employers. So they spend 30% of their time with one, 30 with another, 30 with another, and 10 with another, which just seems an absolutely crazy decision from a practical point of view. So that decision's come out of the European Court of Justice. The McTeer and others case, in the meantime, gets its way to the Employment Appeal Tribunal. And the Scottish Employment Appeal Tribunal says, well, hold on, we've now got this European Court of Justice decision, which would suggest that the employees could actually go to more than one employer. So it's not that they either go to one employer or the other, or they stay with Amy. There's a fourth option, which is they could potentially go to McTeer and Mighty. So for example, if they work 80% of their time on the McTeer contract and 20% of their time on the Mighty contract, they should spend 4 days working with McTeer and 1 day a week working with Mighty. For those of you that deal with stupid transfers regularly, I think you'll agree with me, that just seems like a crazy situation. I can see the legal arguments potentially for it, but from a practical point of view, what that will require really is, let's take the example in this case, McTeer and Mighty really to work together on an ongoing basis in relation to those staff. It's often the case that the new contractors are competitors. They'll have no contractual obligation to work together. How are you going to manage things like who records what hours the individual works from a working time perspective, for example? Or how do you decide if both employers want them to work on the same day? How do you decide which day they work on, etc.? All of these kind of practical issues. So to me, it just seems an absolutely crazy decision. And hopefully it'll work its way through the system and be appealed and overturned. But as things stand at the moment, there is this possibility on a TUPE transfer that an employee could transfer to the multiple new contractors rather than them have to go to one or the other or not transfer at all. So TUPE, it's just the gift that keeps on giving, isn't it? On that, I'm going to hand over to Ronnie to cover IR35 and off-payroll working. I'm sure it's not nearly as exciting as TUPE, Ronnie, but well done for listening to all that employment blurb. I'll hand over to you.
Couldn't ever be as exciting as TUPE, but thanks very much, Morag, and hello everyone, good afternoon to you. Ronnie Brown, tax partner at Burness Paul, and have been involved with IR35 for too long now, in fact since 2017 when it was first rolled out to the public sector. And as you're all aware, it was due to be rolled out to the private sector last April, 6 April 2020. But just about a year ago, the government announced that they were going to shelve it for 12 months, given the COVID pandemic was getting a hold of the country at that point in time. So what happened after that? Well, about a month or so after that, the House of Lords Finance Bill Subcommittee published its report on IR35, and that subcommittee was headed up by Lord Forsyth, formerly known as Michael Forsyth, not noted for his left-wing tendencies, but he poured scorn on the whole IR35 regime, said it needed a fundamental rethink. They said that given it was delayed because of COVID, it would take more than 12 months for the country to recover from COVID, and therefore it was appropriate to delay the introduction of IR35 even further than April. They rubbished the CEST tool, said that it was unworkable, and concluded that it could lead ultimately not to 0-hour contracts, but to zero-right employees, whereby they would suffer the tax implications of being employed but have none of the rights that go with it. What happened? The government published a response which effectively said it was ignoring everything the Finance Bill Subcommittee had to say. And here we are, less than 2 weeks to go, and IR35 will be upon us. So, for those of you for whom it will be applicable, I trust that you're all already well involved in carrying out the necessary due diligence that's required to put yourselves in the best position you can. And what I propose to do is just have a quick run through those steps as I see them again for your benefit. And essentially that starts with understanding your supply chain. As you know, IR35 will apply where there is an end client who is not a small employer, and small means that their turnover of 10.2 million, assets of 5.1 million, or 50 employees. If the end client can tick having two of those, less than two of those, it will be small. So if he's got less than 50 employees and turnover of less than 10.2 million, the end client will be small, and therefore IR35 won't apply to them in the sense of the off-payroll working regime. The old rules whereby the personal service company of the worker collecting the tax will still prevail. But if we assume that we've looked at the supply chain, there is an end client who is medium or large, the question then is, where do you sit in that supply chain? Are you that end client? Are you the person who is receiving the services from the worker? Or are you an agency in the supply chain? Are you onward supplying that labour to an end client? And these are all, fairly difficult questions, revolving around the issue of who is the personal service being supplied to. And I know that a number of you have taken a view that we will not take on labour supply. We will issue managed service contracts whereby we are outsourcing the supply of a service rather than receiving in a supply of labour. But that is easy to say, but not so hard, but harder to achieve in practice. So please be careful in your analysis of your supply chain. It is so easy to get it wrong and to think that you're not an end client when you are. And the ramifications of that are severe, because as has been the case, the end client is the party with whom it all starts, the party who is required to carry out the status determination. And if the end client fails to carry out the status determination, then the end client has the responsibility for the collection of the tax, even if there is one or more agencies between the end client and the worker's personal company. So important to get that right. Assuming you have analysed your supply chain correctly and you have worked out that you are the end client, you then have to carry out your status determination. And in doing that, the obligation on you is to exercise reasonable care. And the tests for the status determination haven't changed. They are, as before, the test that one would apply to determine whether or not anyone was an employee or deemed employee of your organisation. So mutuality of obligation, control, substitution, all of these tests will be relevant here. When I gave a talk on this a year or so ago, I had ran through a number of cases involving sort of household names, where some of these tests had been considered by the tribunal and various decisions had been reached. Since that case, there have been some appeals, and I thought it appropriate just to bring you up to date on those. On mutuality of obligation, HMRC took the case against the Professional Game Match Officials Limited Company, which, and for any of you who attended those talks last year will recall, is the organisation which assigns referees to English games below Premier League level. At first tier tribunal, it was held that there was no employment by PGMOL of the referees, because the referees effectively had no obligation to turn up for a match on a Saturday. If they were going to some other event, they could phone in and say, look, I can't do that game, get someone else. There was no sanction if they did so, and they would be on the list for the following week. So at first tribunal, the revenue lost that, so they appealed to the upper tribunal and have also lost that as well, on the same basis that there was no mutuality of obligation. Contrast that with the case of Paul Hawksby, who's on TalkSport, and who at the first tier tribunal successfully argued that there was no mutuality of obligation between him and TalkSport, notwithstanding he'd been contracted to TalkSport for, I think it was about 19 years at that point. He argued that really they had no ability to insist that he appeared, and there was other factors. They had no control over the content of the show, etc. But when it went to the upper tribunal, the judge sitting in that decided in favour of the revenue. He held that there was sufficient mutuality of obligation, that there was, in essence, a deemed contract of employment between Paul Hawksby and TalkSport. So one for the revenue, which, to be fair, is the exception rather than the rule. And then finally, Kay Adams' case, which you may recall Kay Adams won at the first tribunal. It was held that she wasn't a deemed employee of BBC in respect of her show for it. Again, the revenue appealed to the upper tribunal, but in this case, the upper tribunal agreed with the first tribunal that Kay Adams was not a deemed employee of the BBC. And that was on the basis that she effectively operated a business as a freelance journalist, and her contracts with the BBC were really no more than one facet of that business that she operated. It was wrong to say that because they were of, fairly chunky commitment each year, that they could be viewed as employment contracts. But again, a case which did, say that it's difficult, and that in certain circumstances it might have gone the other way if she were to do more work for the BBC in any given year. Potentially they could have found in favour of the revenue, which all goes to show how difficult it is just to get the right answer to these issues. But nevertheless, the revenue expect that you as the end client will carry out this status determination. And then, having reached a conclusion, you're then obliged to pass that conclusion, together with the reasons for reaching it, on to both the worker, the individual worker, and to the party with whom you're contracting. So that may be the worker's personal service company if it's a direct contract, or if there is a third party between the personal service company and you, then you must hand on that determination to the third party, because in essence it's the third party who would then have the obligation to collect the PAYE and the national insurance before paying the personal service company. As before, you have to allow representations to be made on that determination if the worker or the intermediary consider that you have reached the wrong conclusion, then you must allow representations to be made. And effectively, my view is that that is tantamount to an appeal process. So ideally, it should not be the person who carried out the status determination that hears the representations. It should be someone else within the organisation, so that a fresh pair of eyes is seen to be looking over it. Having got through all that, then I suppose the key commercial decisions have to be made as regards payment. Are you going to continue to essentially pay what you were paying before? If you're paying the PSC, are you going to simply just take PAYE and nix off it, and therefore pay the PSC less than you did previously? Are you going to pay an amount which effectively leaves them with the same receipt that they would have had before, but obviously is a cost to you because you're having to essentially gross up the payment for the tax that would otherwise be suffered? Or at the other end, are you going to pay them even less because you think that you shouldn't be responsible for employers' nicks, and that should be a real cost that's met by the workers' company? These are all issues, obviously, that have to be considered, negotiated, and ultimately, hopefully, agreed between you and the worker or the agency involved. I mean, certainly in the intervening year, we have seen a number of organisations who have moved to an approach that they don't want to have PSCs involved in the supply chain at all, because of the risks and costs that these entail. Again, it sounds, straightforward to say, but in practice, I think it has proven to be somewhat harder to achieve. And I think most of the organisations who have adopted that approach have had to scale back where it's business essential that certain individuals continue to supply their services to that organisation, even though they're choosing to do so through a personal service company.
On that point, Ronnie, there's just a question that's come in that said, a number of companies have decided the blanket decision not to use personal service companies. And the question is, what do contracting companies need to consider to make their case to change that stance? I don't know if you've got any thoughts on that.
Yeah, I mean, it's difficult because, where do contractors go? In 2017, it was easier for contractors because there was an ability to flee to the private sector, but that choice is not available now. And I mean, it harks back to the House of Lords Committee's view that the whole thing has really not been properly thought through, and lessons that could have been learned from the rollout to the public sector in 2017 haven't been learned. So we're really compounding the mistakes that arose then by introducing it without further thought to the private sector. So contractors have some, I've spoken to a lot of contractors over the piece, and a great deal of sympathy for them. But ultimately, I understand where end clients are coming from. It will be a business decision, and if you are sufficiently business critical, I suspect that you will get some leeway that may not be afforded to others who aren't viewed as critical to the business as you may be. Sorry, just another question came in regarding a contractor who works abroad. So IR35 is very much a UK issue. If the contractor is not UK tax resident and is not performing any services in the UK, then there should be no IR35 obligation in relation to the payment of fees to that contractor service company. Equally, if the contractor is based in the UK, but the employer is not UK based and doesn't have a UK presence, IR35 should not be applied to that engagement. The slight difficulty there is the question over to what extent does the contractor themselves, by virtue of being based in the UK and performing services on behalf of the non-UK end client, potentially create a permanent establishment for the end client within the UK. And I've certainly looked at one instance where that's been the situation, because the contractor has the ability to negotiate deals for the end client in the UK, then that effectively creates a UK presence for them, and therefore brings that arrangement within the ambit of IR35. Sorry, someone's asked, what is the position where the determination is undetermined? If there's a change, so if the representation is made and the end client on reflection agrees with it, then or agrees with the representations that they're, for example, outside IR35, because to be honest, I think all representation will be that you've got it wrong, I'm outside, not inside, can't see it going the other way, then a fresh status determination statement should be issued to the effect that it's not within IR35, it's outside, and effectively the contract should proceed on the basis that no tax is collected by the fee payer paying the PSC.
Brilliant, thank you. I'm conscious of time. Ronnie,
sorry, yes.
No, not at all. Just if there's,
just
I don't want
that,
to cut you short.
No, not at all. And I'm conscious everyone wants to get back to things, but just on that point of getting it wrong, HMRC have said that they'll adopt a soft touch for the first 12 months. So if you do, take all reasonable steps and still get it wrong, then HMRC won't look at imposing penalties. They'll still look for the tax, obviously, and will look for interest, no doubt, but they won't impose penalties unless they think there's been some deliberate wrongdoing. So some cold comfort.
Thank you very much, Ronnie. That was really helpful. Conscious of time, past, so we'll let everybody go. I know you'll be heading off to lunch, but as always, if you've got any further questions on anything that we've covered today, do just get in touch, and we'll be issuing the bulletin shortly as well that covers a lot of the cases that we've covered today. So thank you and take care, and see you next time. Bye now.
Thank you. Bye.